Gino, was that you? Okay, we're going to hold off just a couple minutes because I'm one short of a quorum. There were accidents on the freeway, people trying to get parking places and into the chambers here. So we're one short of a quorum. We'll get started in just a couple minutes.
I'll be here, dear. Thank you.
Thanks, Gino. Because Veronica's not voting. Oh, because he's on. Okay. Okay, with Gino we do. That's true, because he just came on. Is David on yet? Okay. That's Gino, but David is calling too. Will we get another Dave?
Luke.
David, are you there? Do we have David too, or just Gino on the phone? Okay, Gino, you still there?
Yes, I am.
Okay, we are waiting for David Bobzian to call in, but with Gino is our sixth member, so we do have a quorum. So I'm going to call to order the Regional Planning Governing Board special meeting of Thursday, December 22nd with a roll call.
Jenny Breckus, Naomi Dewar, Paul McKenzie, Marsha Burkbigler, Charlene Bybee,
Here?
David Bobzien, Gino Martini,
Here.
Ed Lawson, Von Hartung, Jean Herman, and non-voting member Veronica Frankel.
Okay. Also let the record show Naomi Dewar is here. So we do have a quorum. Let me start with a salute to the flag. Ms. Frankel, could you lead us in the pledge? Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, item 3 on our agenda is approval of the agenda. Do I have any changes to the agenda? If not, I'm looking for a motion.
Move approval. Second.
Okay, I have a motion by member Burkbigler and second by Mr. McKenzie. All those in favor?
Aye.
Aye. Opposed? Okay, motion carries. Okay. I do want to check, is member Bobzian there?
Yeah, I'm on. I just got dumped off. Sorry about that.
Okay, no problem. Okay, so let the record show member Bobzian has joined us. And we are on item 4, public comment. Do I have any public comment?
I have none at this time.
Okay, do I have anyone wishing to make public comment? Okay, seeing none, we'll move on to business of the day number 5. 5A is for possible action, consideration and possible direction of staff and legal counsel regarding legal counsel's opinion on the Washoe County bill draft request regarding the Truckee Meadows Regional Planning Agency. And I have I'm going to ask our counsel, Mr. Azevedo, to please make a presentation.
Thank you, Madam Chair and members of the board. For the record, Norm Azevedo. At the last regularly scheduled meeting of the governing board, I was asked to prepare the memorandum which is in front of you, dated December 19, 2016. I presume you all have it. Specifically, the question asked by Mayor Martini was whether a provision of the settlement agreement was lawful. Was it legal? He was specifically referring to the portion of the agreement that required the parties to that agreement, of which Washoe County is one, whether they had an obligation to bring their legislative bill request to this agency prior to submitting it to the Nevada legislature. In the memorandum, as you'll note in the executive summary, the answer to that question is yes. It is a lawful provision under Nevada law, NRS 278.02862, and your own Regulation 10 require any local government, not just Washoe County, to come to this body in a timely manner, which specifically is defined by regulations at 60 days prior to submission of the legislation, to bring what is discussed as or addressed as relevant information. And in this instance, with regard to AB 39, while certain documents were brought to the attention of the agency, none of those documents were brought in a timely manner, nor the documents that were brought with the relevant information. And because we're addressing the obligation of the local governments, AB 39, as it is currently drafted, I think needs to be addressed a little bit, because as I looked at it, it has significant and collateral impacts, not only for Washoe County, but also for the other member governments here, the City of Reno and City of Sparks. But it also goes farther and, in essence, reconstitutes this board and removes a large portion of our region from having a voting voice on this board. If you look at the current composition of the board, it consists of 4 members from the City of Reno, 3 members from City of Sparks, and 3 from the county. The rationale behind that composition and constitution of this board was outlined and addressed in 1989 with the idea that the City of Reno receives 4 votes because it has the most number of constituents. City of Sparks and Washoe County receive similar votes, being that they don't have a large number of constituents. Additionally, with regard to planning matters, a lot of the planning concepts that had come before regional planning, such as intensification of development within the core, of those types of issues, unequally burden the cities as compared to the county. And so the current composition actually made sense, at least from a lawyer's perspective, in that all of the members of our region had a voice to be heard. What is being proposed now is the residents that reside in the City of Reno have their voice being diluted, reduced. Conversely, the proposed legislation under AB 39, in essence, eliminates a voice for the people that live in the unincorporated areas. Much like myself, there will be no member on this board, or could be no member on this board, that would have the issues and concerns of the unincorporated residences. So when I looked at the legislation, was it significant? And the answer to that question is yes. It's significant not only from a voting standpoint, but also from the, how it impacts all of the constituents. In the memorandum, we go into detail of the facts of how the agency was made aware of what was going on with respect to this BDR. These are the facts that the agency was aware of, and I went through in somewhat detail and laid that out. The facts are there, as it allows us to draw the conclusion, in short, that the county did not comply with the requirements of NRS 278.02862, Reg 10, and the settlement agreement. The question becomes, now that you have a violation of state statute, of your regulation, and the agreement, what actions, if any, should this board take? Obviously, Mayor Martini articulated it last time, and that would be the best result would be for Washoe County to withdraw the bill. That is the best result, but that's with outside of this body's authority or jurisdiction to make happen. That's within the jurisdiction of the Washoe County Commission. Alternatively, the range of actions for this body range from doing nothing, taking no action whatsoever, letting the matter lie. There are collateral consequences for that and risks associated with that. Right before this body today, you have a regulation that imposed a 60-day limitation prior to submitting the legislation to be filed with the agency, which was not complied with. If this body were not to take some action to enforce that regulation, that could very well set the precedent for future non-compliance with this particular reg, which is frankly a very important one on the legislative side. Secondarily, this body can initiate a legal action to confirm my opinion or our opinion from the firm that in fact they had not complied with it. The obligations under 0286, the regulation, and the agreement. That action can be filed in court. As I articulate in the memorandum, the remedy for that is uncertain. This particular legal obligation of every member here that is represented by the City of Reno, City of Sparks, and Washoe County, you all have a precondition before proposing legislation that impacts this body and your regulation. These particular bodies of law have never been tested. Courts fashion remedies for legal violations. The range of a remedy could be to invalidate AB 39 as not compliant with a condition precedent, or the court could structure some other type of remedy. That's what judges do. Unfortunately for me, on your behalf, is I have no body of law upon which to draw on to give you a recommendation as to what the court may do. Additionally, and finally, the settlement agreement that was penned and inked in 2002 contains a provision that in essence incorporates NRS 278.02862, goes further and require them under that agreement to come forward to you. That is a legal obligation of the county as well as the two cities that were parties to that agreement and the governing board. And they did not honor that. Under the settlement agreement, you do have the authority to go back to the judge, which is specified in the agreement, which will be Judge Freeman here in Washoe County, to address the actions of the county. And the court then could fashion a remedy as it deems appropriate as to the settlement agreement itself. In the memorandum, Member Bobzian asked one question last time: what happens and what would be impacted if the settlement agreement from 2002 was invalidated? In the memorandum, there is a discussion of all the concepts that were contained in the 2002 settlement agreement that have become somewhat of the foundation of your planning process here in Washoe County. The risk is if you go to invalidate the settlement agreement, some of those concepts may disappear. That would not preclude this body from putting them back into an update, absent the court rendering a decision telling you you can't, which I don't foresee that as being a possibility. But because those concepts are fundamental to the planning process, and frankly have worked quite well for the last 14 years, drawing the jurisdictional boundaries, I think there's significant risk in seeking to invalidate the entire settlement agreement. With that, I will conclude in that, just to start or end where I began or started, it is my opinion, or our opinion, that the county violated state statute, state regulation, the agreement when they did not bring the BDR or relevant information to you in a timely manner. 2, you have several options ahead of you, and I'm here to answer any questions you may have.
Do I have questions? Mr. Bobsian, Mr. Martini?
My question would be to the county, are they going to do away with the bill, or what's their action going to be? Do you have any clue?
I guess what I was going to call for, does the county have representation here, legal representation, that wishes to speak to this matter? I see none. Does Reno or Sparks, I also wanted to get opinions from Reno or Sparks, if they want to comment before maybe we open up to full questioning of the board. Do we have any further comments on what Mr. Azevedo just presented from Reno or from Sparks? Okay, seeing none from staff, do I have questions from board members? So in answer, Mr. Martini, the county does not have legal or someone here to respond to that unless one of the commissioners wants to. Ms. Burke-Bickler?
I can respond by saying that this was a 5-0 vote at the commission to put this legislation forward by documentation, and so it can't, there's not a change that can be done until we're back before a commission meeting. So there's no way to answer the question.
Okay, thank you.
Norm is, question for Norm?
Yes, sir.
Go ahead, Gino.
Can we make a motion to go to court with this unless the county gets together by the next meeting and pulls this bill from legislation?
If I may, Madam Chair?
Yes. Mr. Esposito?
Mayor Martini, if I understand your question, could you make a motion directing legal counsel to proceed to court unless Washoe County withdraws the AB 39 prior to your next regularly scheduled meeting?
I would want, yes, I guess that would work, but if, when is if the county could tell me, when is their next scheduled meeting?
Ms. Burke-Bickler?
We have a meeting on Tuesday, January 3rd, but that is a pro forma meeting, and there won't be any deliberation, and it could not be on the agenda for that. So the next one will be that next Tuesday, whatever date that is. It's the 11th or 10th or something like that.
We're not scheduled to meet till February, right, Kim?
That is correct, Mr. Mayor.
All right, so that would be my motion then, that we should proceed to take the action or turn the action over to the court unless the county decides to withdraw the bill by the governing board's next meeting on November 9th, is it, Tim? What's the date?
Okay.
Mr. Mayor, I will take a look at this really quickly. I believe our next meeting is on February 9th, Thursday, February 9th, which is...
Is that okay with you, Norm? Does that legally meet muster or what?
Mr. Mayor, it does. Just from a timing standpoint, I mean, we can begin the process to prepare the pleadings and coordinate with your director on the timing. If Washoe County on the 11th decides to withdraw AB 39, we can stop it. And even if we do file it in court, we can voluntarily dismiss it. So yes, answer your question.
All right, then my motion would be that we move ahead with to the courts unless the county decides to do away with the bill at their next scheduled meeting or their scheduled meeting of January 11th, 2017. Does that work, Norm?
Yes, sir.
Okay, so I have a motion. I'm going to ask for a second, and then I'm going to open to discussion, because I think I have several members that want to make comments.
I
So,
think the date's the 10th, not the 11th.
oh, January 10th?
And
Okay.
I'll second that for discussion.
Okay, so we do have a motion by Mayor Martini, second by Member McKenzie, and now I'd like to open it to discussion of the other board members. Mr. McKenzie?
Thank you, Madam Chairman. And just for clarification, the way I understand the motion, we're going to proceed with taking it to court. If they don't move to withdraw the bill on the 10th, then the process has already started. We're moving on. If they do, then we can withdraw the complaint from the court. The issue about us making a decision whether to go even further, February 9th, wait until our next meeting for us to make any further action on that. And I don't think that's the way I understood the mayor's motion, but if we were to wait until then, the session's already started, and the bill's already processed. Sometimes started processing. Sometimes you lose control of that at that time. So we'll know on the 10th whether the county's going to do the right thing or not, and if they aren't, well, then full steam ahead is the way I'd understand the motion. Am I correct, Mr. Mayor?
That's correct, Paul. That's what I want. The drop dead date for us to file the motion and move on with it would be January 10th after the commission meeting was over. If they have not made a withdrawal of the bill, then we move it to the court.
Okay. Mr. Lawson, did you have comment?
I just, that was my clarification too, and I understand the motion and I agree.
Do I have other comments? Ms. Stewart?
I understand, and there seems like there's good legal precedent, or let's just say a legal record on 3 documents that you mentioned, the statute, the rules, and the agreement.
There's one more, though.
Mr. Lawson?
Excuse me. Norm, does this, in the way we understand it in Sparks, and we may not be right, it has to go to the City Council of Sparks, the City Council of Reno, obviously the Washoe County Commission, and the Regional Planning Governing Board in order for that BDR to be submitted?
It depends on which particular which document you're looking at, excuse me.
That's not the answer you want to hear. It just depends.
Well, each obligation, just to set forth, you have a statutory obligation. Washoe County had a statutory obligation. They had a regulatory obligation. Those don't require other jurisdictions. That requires a filing here. The settlement agreement has additional requirements. Okay, and we will address each of those in the court proceeding.
But
Ms. Stewart?
So does it have to
Oh,
come to
go ahead.
Sparks City Council and Reno City Council or not?
The proposed BDR, if Washoe County were to submit one, let me check in.
Let's just say we're starting
Okay.
over and it's July. And the county comes to Sparks and says, hey, we got this great idea and we wanted you to run it by the Sparks City Council per the agreement. And then we're gonna go over to Reno and do the same thing again. And then we're gonna go to Regional Planning Governing Board. Or they just go straight to Regional Planning Governing Board and submit the BDR with the approval of the board.
Let me answer your question very specifically.
Thank you.
Because when I wrote this, I looked towards the governing board's obligations. Under the 02862, no, they would not have to go to the City of Sparks or City of Reno. Under the regulation, no, that's a filing obligation that resides here. Under the settlement agreement, and I'll read the language to you. Sorry about that.
oh, I'm sorry.
Reno, Sparks, and the county and board agree, all other legislative items, which this falls under, will be addressed pursuant to NRS 278.02762. There was a typo in the settlement agreement. It's supposed to be 02862. And the memorandum of understanding. The memorandum of understanding under 2001 contains all of the obligations set forth therein. If I have a moment, I'd like to read it, just to make sure I don't misspeak. And it's my understanding, and I'll put a little hedge on this, I didn't really look to the other jurisdictions. As the particular memorandum of understanding reads, the decision to get an affirmative vote from each jurisdiction is not there. There's a duty to communicate it to the other jurisdictions. But I need to take a look at that to be 100% sure.
Thank you.
Ms. Stewart?
I think you covered it. That's exactly I wanted to follow up, because I didn't think it was all answered, your question. So what I heard you say, Mr. Azevedo, is that for statutory change that this body would get involved in, we don't need to go to the cities for further confirmation. For a regulatory change, we don't. But, excuse me, when I said a statutory change, obviously we would need to have a vote of this body to have a statutory change. But not a vote of Reno and Sparks, is what you're saying.
Correct. And if
Okay, go ahead.
guys, I'd make sure I'm clear. If a body wants to, whether it's Washoe County, City of Reno, City of Sparks, wants to propose legislation,
Statutory.
yes, regarding regional planning to the Nevada legislature, the statute says that you have to file it with the governing board. That's your statutory obligation.
This board.
Correct. The regulation says when you have to file it and what you have to file.
Got
It gives you a 60-day window ahead of filing it
Got
and the relevant information. The settlement agreement went further. The settlement agreement incorporates 278.0286, and it also incorporates the 2001 Memorandum of Understanding and all of the duties and obligations set forth therein.
Okay.
That makes some sense. And within that Memorandum of Understanding, it sets forth a whole litany of things, 2 through 6 of the obligations.
And primary is duty to coordinate.
Precisely.
Communicate, excuse me. Is that correct?
Of both, yes, the governing body as well as their lobbyists.
And Mr. Azevedo, to follow through with what you're saying on the memorandum of understanding that was agreed upon by all three entities. So the county and Reno and Sparks signed on to that agreement and the obligations therein for that 2002 settlement, and the MOU was agreed upon. So we all individually from each of our entities agreed with that and obligated ourselves to to upholding that agreement. Am I correct?
Yes, Madam Chair, you're spot on. Specifically, what occurred was during the 2002 litigation, the 2001 memorandum of understanding was incorporated by reference into that settlement agreement as amended, and I couldn't find any amendments of that. And so each body, not only did they approve the memorandum of understanding prior to the settlement, but when the settlement agreement was penned and inked and then executed, each respective governing body of Sparks, Reno, and Washoe agreed to follow that set of rules in that 2001 memorandum of understanding as of the date of the settlement, which, by the way, was then approved by the court. So to answer your question is yes, all the jurisdictions approved it, both independently and as part of the settlement agreement, so twice.
Okay. Other comments? Ms. Burke-Bickler.
So I have before me a.
Madam Chair, this is David. I'm sorry.
I have before me a memo from the district attorney, and I'd like to read some points that he has made. He's pointing out that the Regional Planning Agency's website contains the attorney's memo and a copy of the county's BDR, but it does not publish all the attachments to the attorney's memo. So they're not available to the public, which in fact is the same violation you're accusing the county of. But the memo admits the county's BDR does not violate the settlement agreement provision of Section F. That bars that bars any of the members from seeking to undo the 2002 settlement agreement with legislation. Obviously, a bill that seeks to change the makeup of the governing board or the eligibility of county appointees does not affect the terms of the settlement agreement, which applies to annexation, joint planning, and spheres of influence. The memo tries other routes of finding a legal basis for action against the county, one statutory, one based in regional planning language and monitor, and another based on the recitals of the settlement agreement itself. None hold up in the opinion of the DA. So the statutory issue is a regional planning statute requires local governments before submitting a recommendation for proposed legislation or beginning any program or project relating to the mandatory provisions of the comprehensive regional plan. A unit of the local government or an affected county shall file all the relevant information related to the request program or projected with the governing board. There's nothing in this legislation that does any of those things. It's not meet anything relating to mandatory provisions of the comprehensive regional plan. As for the regional plan language, the attorney's memo also cites Section X of RPGV's regulations on procedure. The memo's analysis of Section X suffers from the same defect as the statutory analysis. Section X also applies only to proposed legislation that relates to the mandatory provisions of the comprehensive regional plan, not to the structure of the board or to who the county can or cannot appoint to the board. And then he goes into the settlement agreement. All this is available. It is available to every member of this board, as well as your both city attorneys and Mr. Azevedo. So this information will be and is available now, so it can be applied to all of you.
Okay.
It would be our recommendation that this board is very careful that it doesn't just step into a lawsuit because it may not win. And so that is the recommendation from our district attorney. So to be exact, what he said was, when I said, do you want me to cover this? He said it would be wise for the county for the board to be careful that it does not push itself into litigation it can't win. That's from the district attorney.
Okay. Mr. Bobsian.
Well, I think my comments are suddenly very different, having heard that. I think it's highly unusual that rather than hearing from the DA directly, we have an elected member that's going to represent an opinion. I think it'd be much more constructive if we had both legal counsels available at this meeting so that we could have a fuller discussion rather than just translations of positions.
Sounds like a threat.
I maintain my original concern, and I appreciate, Norm, that you noted that in your analysis, that any action we take in seeking feedback from the judge as to how this comports with the settlement agreement runs the risk of dumping the whole agreement and all the good that has happened there. So I just want to make the caution that if we go forward with this motion, that we step lively, because this is unfortunately a very hazardous enterprise if we go forward. And I think we do need to go forward, because I trust legal counsel that this is a clear violation. But as we move forward, we and not knowing how the judge is going to remedy it, we just be careful that we don't lose the baby with the bathwater.
Madam Chair?
Yes, Mr. Martini.
Sounds like a threat from the county to me, and maybe if we don't pass this motion, we ought to just pass a motion to go directly straight ahead to the court, because of the anticipated threat that I just heard from Ms. Burke-Bigler from their district attorney. So obviously they're not going to do the right thing and withdraw the bill. So maybe we just ought to go straight to court, let them figure it out.
Okay, Mr. Lawson.
Mayor Martini, if I might, I would prefer to support the motion and always hold out hope that perhaps we can have some additional conversations ahead of the January 10th meeting, and perhaps we can still find some resolution.
Okay, thank you, Mr. Lawson.
I'll heed your savage advice, Mr. Bobzien. You are a wise man, I hope.
Thank you, Mr. Lawson.
Thanks, I think.
So, I'm disappointed to hear that from the district attorney, but it sounds to me like any member can then just change the constitution of the board and the makeup of the board. So maybe we follow a BDR that reduces the county to 1. This is a slippery slope. When we go down it, I don't think this is going to work. So that's why I think for us, we really need to get an opinion from the judge and move forward. And because once again, I'm going to point out, we're in a great position as a region. And this is the last thing we need to do is be fighting amongst each other. So I want to see a peaceful resolution and move forward. But at the same time, it needs to be answered, as I said last time. And if we got to be in front of a judge to get that answered, so be it. Let the cards fall where they may. If the whole regional plan blows up and the regional planning blows up, so be it. It was meant to be that way. So I say move forward the way the motion has been stated.
Mr. Esposito.
Madam Chair?
Yes, Mr. Mayor.
Question for Norm. If the bill that is being proposed down there would open up the regional plan and the settlement and the whole thing, is that not correct?
Yes, sir.
And once that is open, it's all bets are off. Is that not correct? Anything can be changed, anything can be moved, anything can be canceled, anything can be done once that is open, not just what the bill says. At the 11th hour, like I've seen many times, somebody will come through with an amendment and blow up the whole thing, and it'll get approved. Now, so to me, once it's open, and it's all bets are off.
Madam Chair, if I may.
Yes, Mr. Esposito.
Mr. Mayor, I'm not a lobbyist, so I'll stay away from the lobbying issues. But what I would say in this regard is if the court says the agreement has been violated and it is rescinded or what other remedy it fashions, then the answer to your question is yes, it does open that door.
Mr. Esposito, following up on that, we're talking about two different possibilities here. What the mayor is talking about is if the BDR goes forward and is in the hands of the legislature, we all know that more than what is initially intended could happen in Carson City, because most of us know that that opens us up to other changes and things that we might not agree with or have control over. The secondary is the court. So we've got two places right now with regional planning, the update, and our makeup of this board that put us at possible risk of change or blowing up the whole regional plan on two different sides. Am I clear on that?
Yes, ma'am, and you are correct in that the legislative process is a little more fluid than a court process on procedure, so anything can happen is pretty much the rule down there, and so you're open on two fronts, potentially, if this bill goes forward.
Madam Mayor.
Ms. Stewart?
Yeah, thank you, Madam Chair. From where I sit, I would just like to respectfully request that the county take everything that they've heard here today, bring it back to their other members. I know they can't take an action today. I rarely look for negative intent when people do these things. I think they're trying to remedy something that they see a problem with. But that said, so my desire is to preserve the peace. I think that's the greater goal. And all of these documents, the statute, the regulation, the settlement, the MOU, have been carefully thought out by people that came before us. And I think any change also needs to be carefully thought out before it moves forward. And I think that's why this provision is in there, so that it does give time for the parties to consider what's being proposed, think it through, maybe come up with another alternative that avoids having to make a statutory change. So I would just say that there's an opportunity here. We don't have to do brinkmanship, in terms of, well, if you don't do this and I don't do that, and we're going to do this and then you're going to do that. We're not in an inexorable pattern here where we must act in a negative fashion to each other. So I would just, again, respectfully request to our colleagues from the county to carry the message that this is not who is bigger, who is badder, who's in charge, but a respect for what has come before us and the people have come before us. And that's, just my message of peace. And if you do change your mind, I personally, and I doubt many here, would sort of say, we won, you lost. I think they would acknowledge that you thought about something and made a change. And it's not a win-lose kind of thing. So that's just my perspective, but thank you for that chance.
I guess what I would like, I appreciate your comments, Ms. Stewart, because really, this whole agreement and the whole structure of regional planning did come years before. It came with Senators Townsend and Raggio and Wagner at times where there was a lot of conflict and a lot of, way before me or most of us sitting here were involved. And they saw an issue with cooperation amongst the three entities and looked for a remedy to that. So it's kind of ironic to me, that's why we're here. We're here as a regional governing board because our duty, as I see it, is to work together in cooperation with each other in a way that benefits our residents, that benefits the Truckee Meadows and the people who live here. And now more than ever, the importance of that with the growth that we are seeing, more important than ever, our planning efforts and our cooperation and working together on all fronts is more critical probably than it's ever been. And so the representation on this board and really the intent that they had back when this was all, when those leaders who saw issues and found a remedy that's been working for 14 years, it was very well thought out. I mean, they were looking at representation of Reno representing the highest population. So the representation of one additional seat gave them that, but gives them no authority over the other two because 4 of them alone cannot change the course of what this board does. So it still gave representation to the people. The unincorporated counties having 2 designated, county commissioners or representatives from the unincorporated part of the county, I think was also important because it shouldn't be the urban centers that dictate everything about regional planning. You've got people in the unincorporated, and you've got a lot of land and a lot of development that would come there. And so the intent of that to me, and this is just my read of what their intent was, and in talking to at least one of them, that's what their intent was. So for me, It's about balancing us doing the right thing for the residents of the Truckee Meadows and representing the residents of the Truckee Meadows fairly, the unincorporated and the population. It's not about, it's not about the powers of the three entities involved. It's not about the city of Sparks. It's not about the city of Reno, and it's not about Washoe County. It's about the residents, and it's about the people who live here, and us doing the right thing for them. And that's where I feel my obligation is, and our obligation as this regional planning governing board is. And I think looking at violations, legal violations that have occurred, hard to ignore, if there are no consequences to violating, the several violations here, but violations in general of NRS, of board policy, if there's no recourse, then that opens it up to precedent of any of us at any time not abiding by things, especially when we've signed on to do that. So I think action needs to be taken. I would be hopeful, as Ms. Stewart is, that we can work through this with the county, that we can sit down and figure out what is in the best interest of all of us. But I think I would not support taking no action because violations have occurred, and we need to resolve this. And I'm hoping, in the spirit of the season too, that we look at respecting each other, working together, because that's the purpose of why we're here. It really is. Other comments? Any other board members? Mr. Azevedo.
If I may, Madam Chair, make one comment in response to what I heard from what was read, apparently from the District Attorney's Office. They seem to focus on the term mandatory provisions of the Comprehensive Regional Plan. There is additional language, and what I would submit for this board is we looked into this issue. And from my perspective, Washoe County did, and you'll note in your, make sure I cite the right section, the procedural history of AB 39, there were filings with this agency. So her client's own actions, or the district attorney's own client's actions, are inconsistent with their opinion. There were filings, as you'll note, on August 31st, they filed what we thought was going to be a review of comprehensive regional planning with your agency in furtherance of NRS 278.02862, Article 10, but they did so in an untimely manner, and they did so incompletely. So I just thought I'd throw that out there so you can take a look at that. And additionally, at the conclusion of this, I'll hand Member Burke-Bigler my packet. The entire packet was filed with the agency, so the whole thing is here for you. Thank you.
And Madam Chair?
Yes, Mr. Bobzien?
Yeah, and I think fresh off of those comments, back to what I said earlier, I mean, I think I see opportunity for a productive conversation between the district attorney and Mr. Azevedo to kind of go through the specifics of the conflicts of their two analyses. I do think that if the two sat down and they really went through it, I trust that the professionalism might yield some new opportunity to move this forward and not have to go down the road of brinksmanship, which it seems like we're doing. But I think in the meantime, it is prudent, as was urged by council, that, for us to not act on this definitely opens us up to future problems. So I will be supporting the motion.
Madam Chair, I call for the vote.
Okay. Hearing no further discussion, call for the vote, the motion by Mayor Martini that, do I need to repeat the motion? Okay, so the motion that's on the floor with a second by Member McKenzie. All those in favor?
Aye.
Opposed?
Aye.
Opposed? I'm opposed.
Opposed. Mayor Martini and Mr. Bobzien?
I voted aye.
In favor, both of you?
Yes, me,
Okay. Jeannie? You were yes or no? Okay. Okay, so let the record show.
Yes.
We have all members in favor. Member Burke-Bigler is opposed. Motion carries. We'll go ahead and move forward from there. The next item on our agenda is item B for possible action. Consideration and possible action to form the Regional Planning Governing Board Legislative Subcommittee for the 2017 legislature. Director Robinson?
Thank you, Madam Chair. This item asks for the board to consider and possibly form the legislative subcommittee for the 2017 legislature. This is a subcommittee that historically has been put together here at the governing board and generally is made up of the chair, the vice chair, and the immediate past chair, which also allows each jurisdiction to have one seat or one vote on the legislative subcommittee. The idea being that, and I'm sure most of you are familiar with this, that things can move pretty quickly at the legislature. The idea of having a subcommittee that can respond a little bit more quickly to some of the pieces that are moving. It's been very effective previously, and so we're asking today, it would look like your chair, Charlene Bybee, David Bobsey, your immediate past chair is Vaughn Hartung. Again, that's one member from each of the three jurisdictions. We're asking today if the board would like to go ahead and form the subcommittee, if that structure is okay.
Madam Chair, I'd make a motion to that effect.
Okay.
Second.
Okay, motion from Member Dewar, seconded by Member Lawson. I do have one comment on the suggested motion you presented to us. I would like to look at the appointment of alternates also, because I think it's important that three of us would serve, but if we needed an alternate, how have they in the past decided on alternates?
Madam Chair, that has been conversation at the dais. Historically, what it looks like is then again, it will be a member each from Reno, Washoe County, and Sparks, but it gets decided here in the board conversation and it gets named. So if you were to take action on the first motion today and then have a conversation about who could potentially be alternate and have a second motion, that would work effectively.
Okay, so let's go ahead and vote on the first motion of simply forming a legislative subcommittee of the Regional Planning Governing Board consisting of the current chair, the assistant chair, and then the previous past chair. So I have a motion and a second. All those in favor?
Aye.
Opposed?
Aye.
Motion carries unanimously. Okay, so we're looking at appointment of alternates.
Can I just suggest we go backwards and keep going backwards to chairs and vice chairs, or
That
Well,
is certainly an option.
I don't even know if they're here, all the last three.
oh, that's
Chairs,
true,
vice
I
chairs.
didn't think about that.
But do you
I'll
do you wanna do it,
volunteer on
Paul, or do you-
Sparks' side if that's okay.
Second.
Okay, we're-
No one asked you.
We just volunteered you, Gino.
Okay, so Mr. McKenzie's willing to do it for Reno?
Okay, so I guess each entity choosing their own. So we're looking at Mr. Lawson from Sparks, Mr. McKenzie from Reno, and then Jeannie with the county. Do you want to be the alternate, or I guess you're the only one here? Would you be the alternate?
All right, well, Madam Chair, I'd make a motion that Mr. Lawson, Mr. McKenzie, and Ms. Herman be appointed as alternates for their respective
Okay, I have a
representatives.
second by Member Bobsian. Any further conversation? All those in favor?
Aye.
Aye.
Opposed?
Aye.
Motion carries unanimously.
Madam Chair, just one quick item. In the motions, it did describe chaired by, historically, that is the chair of the subcommittee, the chair of the governing board themselves also chairs the subcommittee, and directing staff to work with the chair to do the initial meeting dates. If the board is amenable to those, we don't need another motion, we can just move forward with those
Okay.
items.
So is everyone agreeable to that? That Kim will work with me on setting future
Yeah.
So
meeting dates?
are we going to work under the 2000 memorandum of understanding about legislative?
We're gonna hire another attorney to get another opinion.
Okay. So we're going to let them, Kim. Okay, so moving forward, item number 6 for possible action, members' reports. And I'd like to call on Ms. Frankel. Do you have any report? I'd like to include you in this section, non-voting member, but report at each of our meetings on things going on with the school board that we would need to be apprised of.
Well, I appreciate that, Madam Chairman. As many of you know, the Washoe County School District Board of Trustees on Tuesday approved the recommendation from the Capital Funding Protection Committee, which is an oversight committee for the use of capital funds. And it was the first such vote following the passage of WC1. At that meeting, we approved over $76 million in funds for construction and repairs, as well as land acquisition and planning. And I'm very excited about that, and we are extremely excited about working with all of your jurisdictions, and I know that there's going to be a lot of need for ongoing collaboration regionally. To echo some of the comments made previously, the school district really relies on the collaboration and this regional coordination that happens because these decisions really impact the kids and impact our schools. So we look forward to that, and I'm happy to answer any questions if you'd like to know more about what we decided, but it involves the first step would be we're breaking ground on expansion of the Damani Ranch High School. Within the next 2 weeks, we anticipate that expansion will be complete sometime during the first semester of next year, the 2017-18 school year. The subsequent project will be the construction of an elementary school in the South Valleys. We already are looking at the land, and there's going to be a lot of work done in that area, working with regional planning and others around the impact of that project. So that school we're slated and hopeful will have up and running by the 18-19 school year as an elementary school in the South Valley. So those are the two initial projects. The land acquisition involves many different conversations with many different entities, including some represented on this commission, on this board. And again, we really look forward to working with all of you to make these schools and this construction process happen. And thank to all of you who serve on the Capital Funding Protection Committee, because we know that work is difficult, and we appreciate your involvement and your thoughtful contribution to that process.
And Ms. Frankel, to be clear, the $76 million that was just approved is still bond rollover money. It is not, because a lot of people are still confused on the sales tax does not take effect until April. So that money that was just approved is actually from rollover bond money that was already.
Yes, we received
accounted
additional
for.
bonding authority at the last legislative session, so that is correct. The funds, the $76 million is not from the recent bond of WC1, which, as you mentioned correctly, that will not start being collected until April and not available to the district for bonding until June of next year.
Okay, just want to make that clear for a lot of people that are still questioning everything about it. So I like to make that, probably because I sit on the committee too, just make it clear to the public, because we want everything to be very clear and transparent.
And one of the things I'm happy to suggest, or actually make happen and work with this board, if they're so interested, is having a presentation from the school district if you're interested in hearing more about the capital construction plan and getting more information about that. I would be willing to help make that happen if that's something folks are interested in.
Okay, thank you. Director report, Ms. Robinson.
Madam Chair, I have none.
Okay, going to item B, legal counsel report.
Nothing further.
Okay. Item number 7, requests for future agenda items. Actually, I would like to request a presentation by the school board at a future meeting to give us more update on what the capital expenditures and plans are, especially because it does relate directly to planning and what we are all doing in our individual entities, but as a community. So I would like to request, and no date certain, whatever works sometime in the future. Other future agenda items that anyone wants to request? Okay. Item number 8, public comment. Do I have any public comment? Okay, we have no cards. Does anyone want to make public comment at this time? Okay, hearing none. Move on. Item 9, written correspondence.
Madam Chair, we have none.
Okay, moving on. Item 10, possible adjournment. Move to adjourn.
Second.
Okay, a motion and a second. All those in favor?
Aye.
Aye.
We're adjourned. Thank you, gentlemen, for being on the phone.
Bye-bye.
Thank you, Madam Chair.